Hi everyone, and welcome to the Fake Love and Flying Monkeys podcast. My name's Nova Gibson and I am your host. My area of expertise is in supporting victims and survivors of narcissistic abuse and other toxic relationships. I'm the principal counsellor at Brighter Outlook Narcissistic Abuse Counselling Service, and I'm also the author of Fake Love, Understanding and Healing from Narcissistic Abuse. In this podcast, we're going to be talking about everything from the initial pink cloud you find yourself on at the start through to the horrific discard and the powerful trauma bond that keeps you hooked. So take your imaginary seat on the roller coaster that is narcissistic abuse, and don't forget to subscribe to this podcast so you never miss an episode of Fake Love and Flying Monkeys. Hey everyone, and welcome to another episode of Fake Love and Flying Monkeys. I know I tell you I have some exciting guests on my podcast. I think all my guests are exciting, but today I'm really excited to introduce you to my daughter, Courtney. Courtney is a lawyer and she has her own law firm here in Brisbane, Queensland, Australia. And she's a bit of an expert in her field in that after a whole lot more study, she became a family law specialist. So Courtney is an expert at working, knowing the family court system. And you know what? I'm just going to shut up because I'm not a lawyer, and I'm just going to introduce you to Courtney, my daughter, Courtney Barton from Barton Family Lawyers. Courtney, I finally got you pinned down to do a podcast with me.
Hello, how are you going today?
I'm good. Now, Courtney, everyone, well, not everyone, I think a few people out there know that you're my daughter. And I was talking about the kind of the differences we have with another KC in the UK a while back, in that I come from a counselling perspective with my clients, and obviously there's going to be a big difference between the way, you know, we see things clearly, because you're the expert in family law, and the law is the law. And that's why I wanted to introduce you to my followers today, so you could give your expert, I know you can't give, full-on legal advice, but you could really help the victims of and survivors of narcissistic abuse out there who are really struggling and are scared to take that first step in getting a lawyer and potentially, finding themselves in court with their abuser. So can you just tell everyone a little bit about yourself and what you do?
Sure. I'm a family lawyer and director of Barton Family Lawyers. So at Barton Family Law, we specialise in supporting victims of domestic violence, coercive control, narcissistic abuse to take their power back. So what that looks like on a day-to-day basis is we represent the victim and we support that person to ensure that they can regain control of their life, whether it be through their finances, dividing their assets, having a formal arrangement entered into in relation to their children, or also finalising their divorce. All of those steps to allow them to move on with their life and achieve the best practical outcome for them and their family.
Yeah, and I always tell my beautiful clients when they come to see me, and they've either been discarded by their abuser, they've had their light bulb moment, and they're pretty sure they're dealing with a narcissist, given that it's not likely they're going to get a diagnosis. But I always say to them that I know you're feeling the lowest you've ever felt, but you've got to go and get legal advice, because you can bet your bottom dollar that your abuser, who potentially controls everything, that they're going to be getting all of their ducks in a row. So can you talk to everyone about your views on when you should get a lawyer if you particularly recognise that your partner is abusive?
From my perspective, the earlier the better. Going and receiving legal advice from a family law practitioner doesn't mean that you need to act on it. That advice is confidential, and you can use the information, valuable information and advice you receive to make smart decisions both pre and post separation about what you do to get your ducks in a row and make smart decisions moving forward, which will reduce the financial and emotional cost of separation. So the earlier the better. I would say less than 5% of my clients come to me pre-separation, but it's those people I can help the most. The things that we talk about that often fall by the wayside when I have clients coming to me post-separation are what they need to take when they leave the house, if they leave the house at all, or whether they'll stay, and putting in place boundaries and support mechanisms for them so that they feel safe and their children are also safe, right down to applying for child support and changing passwords on bank accounts and anything else that the other party can access. All of that is the very valuable information and advice we can talk about pre-separation, and even putting in place what I would call an exit plan so that they can press the go button when they're ready to get what they need out of the house and get them and their children to a safe place.
Sure. So, Courtney, how do you support someone who is just obviously so traumatized by their abuser, and they really don't want to go to court, and potentially, you know, I hear this a lot where they just want it to all be over, and they've got a lot of the time no idea around what the asset pool is, what they've got no access to resources because 9 times out of 10 they've been financially abused. So and they just want it to all be over, because at that time they still think their abuser's just going to go away, when if there's children involved, they're certainly not going to go away. So how do you support them to keep going when you can see that their future is on the line and they're just done, that they just think they need it to all end?
Well, that would be every single one of the clients that comes to me who feels that way. So I think there's a couple of questions in there. The first point would be in terms of me supporting them. A lot of that involves more than just simply providing legal advice. I can't be their counsellor. I can be the legal strong arm, but not their emotional one. So my first port of call is always to give a referral to make sure that they've got the appropriate support mechanisms in place, including someone like yourself to provide counselling for them. I think that's really important as a first step, because my clients will always experience, and I say this to each one of them, that things will get worse before they get better. So they need to be in a good or a better emotional place to be able to tackle those hurdles without falling apart. And so I think it's really, really important that they have that counselling support, and also just family support from the outset, so that when those hurdles arise, when the ex is telling them we'll do it directly, forget your lawyer, they don't know what they're doing, and trying to separate them from their support mechanisms, that they have that fully informed understanding of A, what their rights are, but B, the fact that I don't need to do what this person is saying just because that's what they want. I understand that it's best that I stay with my lawyer, because otherwise what I find is that the ex-partner goes underneath the table and just manipulates the situation, and my client ends up right where they started. The second question you referred to was wanting to avoid court and wanting it to all be over. Is that right?
Yeah, a lot of them are just, well, they're rock bottom. and they've been abused for so long, and they just don't see their abuser giving in, and the post-separation abuse has been horrific. They know, or they fear, their abuser will manipulate the court, and that the residual effects of their abuse, e.g. anxiety, PTSD, etc., will actually be something that's used against them, and everyone will believe the nice, charismatic narcissist, and it really scares victims from going to court.
I think that's a bit of a misnomer, to be honest with you. It's not true that someone suffering from a mental health issue is necessarily going to negatively impact their matter, but I might park that part of the answer and go back to avoiding court to begin with.
Yeah, I think it's, sorry, Courtney, I think, I agree that it's probably a misnomer. I think this is what the victim has been conditioned to believe by their abuser. Their abusers told them they're crazy, they're on medication, and they just are still falling into the trap of believing that their abuser will manipulate the court.
Most of my clients have very similar experiences, unfortunately, that I support. So in terms of addressing that particular question, which I might do now, in so far as the relevance of a mental health issue, let's put it at its highest, that a client of mine's been diagnosed with anxiety, depression, PTSD, for example. Yeah. Those issues are not necessarily going to be relevant in a parenting matter. So the Family Law Act says that there's now 6 factors of relevance, and then there's a catch-all any other factor. There's no factor for mental health. There is just a factor for the capacity of the parents to provide for the needs of the children, physical, psychological, emotional, cultural, and also focusing on the safety of both the children and the parents. So mental health is only relevant to the extent that there's evidence that that mental health issue affects a parent's capacity. I would say that more than half of my clients who go through court are diagnosed with a similar mental health issue. And in none of those circumstances have they not achieved an outcome which involved them spending regular time or having primary care of their kids. So it's definitely a misnomer, but I do appreciate and understand that they're worried about going to court and their ex using it against them. But what I would say to that is, as long as they are receiving that support, so don't not go to your counsellor. It's a
I think
thing that you're going to your counsellor and getting support, because if you're getting that support and you're complying with your treatment recommendations and you're taking your medication as prescribed, that's a good thing.
Yeah. And that's what I always tell my clients, but it's really good that they hear that from you, because while their fears might be based on a misnomer, it's real for them, because they've just, they've been gaslighted for so long, and they fear that what their abuser is telling them is fact. So it's really good that they hear that from you, that it's okay to go and see a counsellor. Some of my clients are so worried about having records subpoenaed that they told me that in the past they've held off on going to counselling because they're scared that the documents, those notes that their therapist takes will be used against them.
Well, let me address that specifically. Whilst it is absolutely always a good thing for you to go and receive counselling, and I'd be really concerned about someone coming to me and saying they won't go to counselling because they're worried of the notes being subpoenaed. I can put myself in my client's shoes and appreciate where they're coming from in terms of the continuity of that relationship and not wanting their private information that they're discussing with their counsellor before the court. Sometimes it can be avoided, but if there is an assertion that their mental health does affect their capacity, it may be that those mental health records are relevant. And look, that's a downfall of the system, but that's unfortunately, it's not going to change, because when there are competing allegations of fact in relation to relevant issues that are relevant to the kid's safety, having those records before the court is really important. But what I can do in terms of advocating for my client is, for example, we could seek orders for boundaries around the documents that are produced and provided. Sometimes I've had orders made so only the lawyers can look at the documents and not the parties, which means that that cycle of extended abuse doesn't continue, because it's only, for example, the father's lawyer that's looking at it and not the father. And all the father's lawyer can do then is provide a summary of what's in it, which from my perspective, I think minimises the harm to my client, rather than them having copies of their medical documents.
Yeah, I didn't know that, so that's good to know.
That's quite common in relation to all sensitive material medical records, Queensland Police, Department of Child Safety. It's most common that only the lawyers will look at the documents, and that only the independent children's lawyer is given leave to copy them.
Yeah. Okay. So my clients, many of them, are struggling after the discard, or they've managed to escape. They are absolutely struggling, even after they've secured a lawyer, to try and co-parent with their abuser, because their abuser, the toxic party, has never shown any interest in the children most of the time, or they've been completely over the top in that the children are viewed as their property, and you're a thief stealing their property. At any rate, the children are weaponized, and I wrote about this in my book quite extensively, that you simply can't co-parent with someone who is counter-parenting everything that you do, and they find that out, that they just end up having their abuse extended. So when you've got a client and they're terrified of seeing their abuser at things like pickups and drop-offs, or just speaking to their abuser sends them into a full-blown panic attack because they have PTSD. It's a major trigger. What can you do, and how does the court look at that now? Because so often I hear from them, I've got to speak to them because, otherwise the court will think I'm alienating them. They'll think badly of me as a parent. How do you support parents that literally have their abuse extended because the abuser weaponizes the children?
So if we're talking specifically about boundaries in relation to contact and communication with the other party, I would say it's really important that you have a good lawyer to negotiate those boundaries for you. In terms of what the court does, at the end of the day, if your lawyer isn't advocating for you and putting the right information before the court that's relevant to why a particular order, whether it be that changeover be at a contact centre or that communication only be in writing by email, all of those things, then the court may get it wrong. So you need to have a good lawyer that's putting in the information as to why this particular order is in the children's best interests, because only 3 to 5% of matters will ever reach a trial stage. So the court actually has very little involvement in determining the matter. They make an interim order, either by consent or by the court, but that interim order is temporary until a trial. And most matters, 95% of matters, will settle before a trial. So those boundaries are really important, but I would say making sure that your lawyer is aware of the relevant information and putting it in the affidavit and making appropriate submissions on your behalf is what's most important to advocate for you, so that you can have those appropriate boundaries put in place to manage the client's anxiety and stress. And the other point I would make is that having mental health records, so a letter from the client psychologist, evidence to support the fact fact that not only this is their diagnosis, but this is the genesis of their diagnosis, i.e. they have been seeing me for 3 years and have made various reports in relation to family violence X, Y, Z, and the genesis of their diagnosis is because of the family violence they've experienced. So that factor is really important because, for example, if you're making an argument that a parent's parenting capacity would be impacted if they had to have any contact with the other party, which might mean no contact with the children and them at all, you really need some good cogent evidence as to how that parent's mental health is affected in order to support the order that you're asking for. So it's a tipping edge. I know clients are concerned about putting forward information about their mental health, but I think it's always a good thing. And in circumstances where you're asking for a no time order, for example, that kind of thing is vitally important. Because there are cases where the court says, okay, there's a real benefit to a relationship between the children and this parent, but if it's agreed this person is going to be the primary carer and their parenting capacity is going to, on the evidence, be so impacted by the ongoing contact between these two parents, is the benefit versus the cost worth it? And that's the question the court needs to answer.
So you just supported what I always say to my clients, and I wrote about in my book, which is not just any lawyer that is going to benefit you. It has to be someone like yourself who is experienced in these matters, because the wrong lawyer will encourage you to co-parent, and often the victim already feels like a failure. They've got no self-esteem, no self-worth, and they're doing everything in their power to try and co-parent with this person who just uses their attempts as another way of extending the violence. So the right lawyer, as you said, will put that case forward to the court. So guys, make sure you've got a lawyer you trust. Trust your instincts and make sure they're experienced. Someone like Courtney in dealing with these types of people and know all of these, I'm not going to call them loopholes, but all of these just things that relate to the family law when it comes to domestic violence victims. So speaking of getting the right lawyer, Courtney, I have found more often than not that when people come to see me, they seeing their abuser when they finally get a lawyer, because they'll, as you know, they'll get a lawyer, then that lawyer, they'll drop them because they won't be, ethical enough, or unethical enough, I should say. Then they'll self-represent, then they'll get a lawyer for a while, all the while extending the victim's misery. But when they do get a lawyer, it seems to be this pattern that they manage to find a lawyer who seems as I don't know, kind of unscrupulous and really as vicious as their clients sometimes. Is that something that they just keep going until they find someone, number one, or number two, is the lawyer just forced to do what their client says, which is basically to put the victim through hell? And how do you deal with those types of lawyers who just ignore subpoenas and just don't want to get this thing over and done with, just extend the victim's misery? How do you deal with those types of lawyers?
There's a fair few questions in there.
I know. Sorry.
I'll start with agreeing with you that most parties will find a lawyer that aligns with their values. That's natural and normal. We befriend people who are like us. So, of course, you can find a lawyer who aligns with what you want, and the personality and type of advocate you want as well. And a lot of the time that means that I'm dealing with lawyers who are as coercive, aggressive, and narcissistic, although
Nasty.
nasty is a better word than
Nasty.
trying to diagnose a lawyer.
Yeah.
But it is really hard.
Yeah.
So in terms of how I deal with those lawyers, because it does make it more difficult for the client in terms of the nature of the correspondence, and I'm having to manage my client's response to it and really explore with them what they need to focus on and not focus on, because the intention behind the letter is to cause pain. Whereas an advocate that really is solution focused will find a better way to communicate, even where the parties disagreed in terms of their positions.
Yeah.
In terms of how I deal with those lawyers, there's a couple of things. I don't fight fire with fire. Reaching their heightened level only extends the conflict. So I fight fire with water, which means keeping things respectful. And setting boundaries as to the type of communication I expect. So teaching people how to treat me. And to the extent where that's not possible, we need to look at what the options are to progress the matter forward. And that might mean going to court if mediation is unsuccessful and the other party is being unreasonable. I would say that it's rare for a lawyer to ignore a subpoena. I think there are lawyers out there who use certain parts of the law to their benefit in order to achieve certain outcomes. But I would say that mainly relates to the delays in the court system more than anything else, and extending the costs for my client, which might at some point.
Yes, that's a big one that, people talk to me about, is that, and one of the reasons that they end up giving up, because that's exactly what their abuser wants to do. It goes on, and all the while their costs are going up, and sometimes it's not about, or many times I should say, it's not about the money to the abuser. It's about keeping you in contact with them, making you think about them, just doing whatever they can to not sign those divorce papers and make you spend as much money as possible. It's just about punishing them for being able to live without them. So I don't know if it's, and maybe it is sometimes, but I don't know if it's maybe the lawyer who's ignoring the subpoena, or their client who's saying, no, stuff them. I'm not giving them that. They can wait for it, and they wait till the death knell. I mean, I'm sure there's times when their lawyer's just got no control over their client.
A couple of things. A subpoena is directed to an entity, not a party to proceedings. So that would include, for example, police or a medical practitioner, or maybe the husband's accountant, something like that.
Yeah.
If the husband was directing his accountant not to provide documents, what we would do in that particular type of circumstance is seek an order for compliance by the accountant, and in the absence of that, the accountant can come to court and bring the documents to trial and give oral evidence at trial. So there are always ways around people not complying with their obligations. There is a rule of disclosure, which means that each party is legally required to provide full and frank disclosure of the asset pool, their financial circumstances, and that obligation extends from the beginning of the matter to when a consent order is reached or a trial. So if that obligation isn't complied with, and both parties are required to sign undertaking saying they have complied with it, and to acknowledge that it's an ongoing obligation, and failure to comply is or can be contempt of court. What that means at a trial is, say a party has not complied with their disclosure obligations and information comes out that the asset pool is other than as they've asserted, the court can make negative inferences. So there's a case called Weir that says that the court can make inferences that are negative to the party who's failed to disclose, and they could be quite negative to the effect that significantly reduces that party's entitlement.
So basically the court would punish them for lying.
In effect, I wouldn't necessarily put it that way, but in ensuring justice and equity between the parties, if there's evidence to the effect that disclosure hasn't been complied with by that person and the pool is actually more than what they've asserted, then they're going to balance things in favour of the person who wasn't provided with that information, because in effect the pool is greater, so that person should receive more than the person who lied about this additional property or bank account and asserted it didn't.
So that brings me to my next question, which is financial abuse just goes hand in hand with narcissistic abuse. Not always. Sometimes it's the victim who controls the money, but they're having to pay credit card off after credit card because the abuser is using them and spending all their money. But more often than not, they've got access to nothing. And, I hear people commenting on my live streams all the time about, I've got no money, I can't even get a lawyer. And he or she is, paying a $5,000 barrister a day, etc. So what do you say, what advice do you give to those people who don't even know what their asset pool is, let alone have access to any money to be able to survive?
So there's two,
or pay for your services.
There's two issues there. Firstly, in relation to the property pool and identifying the assets, liabilities and superannuation that exists. So in that regard, I'd refer to that obligation of disclosure that I've just been exploring with you. If that obligation isn't complied with, there can be very negative consequences to that. And in the meantime, if the other party isn't complying, my advice to my client would be to commence proceedings, to seek orders for disclosure, specific disclosure, and in the absence of it being provided, we could file an application in a case and we could potentially seek costs. The other option is subpoenaing documents as well to get that information before the court. Usually in most circumstances, a party will ultimately comply when the matter's before the court. And those are the appropriate mechanisms of getting the assets, liabilities and super identified so we know what exists. Obviously, where there are properties and businesses, we need to get valuations. It's a common occurrence that I have the other party say, the business is worth nothing. This is the letter from the accountant proving that. So obviously we don't trust the accountant acting for the husband that the business is worth nothing.
Really? You don't trust the accountant as if your client who's the victim is saying no it's worth lots more. Do accountants actually put themselves out there and lie for their client?
I wouldn't call it a lie. Accountants are in a position to give an approximate understanding of what their perspective is about the value of the business based on the financial statements, but that doesn't mean that that's accurate. They're not valuers, so they don't have the appropriate qualification to value a business, and they're not taking into account the future maintainable earnings of the business and how that affects the valuation. So that's why we need to get a valuer to value the business. And then the other point would be that the accountant is clearly biased towards the husband.
Yeah, I was going to say you need someone who doesn't have any connection, bit of a conflict of interest. So what
mentioned litigation funding and getting funds for my client. You wanted me to explore that?
Yeah. Yes.
Okay. So I would say most matters where I act for the victim, we need to apply for both spousal maintenance and litigation funding. And that's really important from my perspective, not just so they have the money to pay for my services, but to put them on an even playing field with negotiations. So doing that as early as possible and seeking interim orders means that pre any real negotiations and mediation taking place, they have sufficient money to be able to pay their lawyer so that they're not stuck at the mediation saying, oh, I don't have any more money in my account or that I can lend in order to pay my lawyer, which puts them at a disadvantage in negotiations because they need to bow out, whereas the other party might have significant access to resources.
Yeah.
The other thing I would say that often parties aren't aware of in relation to both seeking spousal maintenance, if they are entitled to that to support themselves, if they can't support themselves on their own, and also in relation to litigation funding, is that it is possible to access assets from the property pool. And quite frequently, I'm seeking orders to sell assets or to remortgage the home loan or even sell the property. In order to make a cash payment to my client, in order to pay both their maintenance and legal fees. And that's quite a common scenario that the court will make orders to sell an asset to facilitate that. Yeah. It's part of the client's entitlement anyway. So if we're just addressing litigation funding, why shouldn't they get it now if we know that their entitlement is 50% and they want 5% now? There's no reason why the court.
What if you don't know what the asset pool is to begin with, and you start representing a client, then you find out, 2 months down the track that there's no resources there.
But we wouldn't go to court in that circumstance if the asset pool is nothing. So we would identify the asset pool first, making an application, which means disclosure, valuations, etc. There would be no point me making an application for litigation funding if I didn't know a resource from which that could be paid to my client. Okay,
so let's just for the people out there, Courtney, who there's just nothing. That maybe, I don't know, their abuser was a big gambler or didn't work, and or they've just gone and blown all the money, and there is nothing, and they can't get a private lawyer. Where do they go to? I know there's going to be people listening and watching from all over the world, but in Australia, where do they go if they need legal assistance?
So the first port of call I would recommend is a community legal centre. We have them in various suburbs in Brisbane. I'd be booking an appointment at one of the community legal centres to seek advice. Yeah. The other option is legal aid, which can support people mainly in parenting matters, but sometimes also combined parenting and property settlement matters. Yeah. And sometimes receiving that preliminary advice is all that's necessary for them to make those smart decisions moving forward. Maybe they don't need to do a formal property settlement. Maybe they just need to arrange with their ex to transfer the car to them. It just depends on the individual situation as to what's best for them and what's cost effective in the particular circumstances.
Yeah. You touched on earlier about the victim or a client who, well, we both did, who's got no access to resources. And often it's those victims who are like a stay-at-home parent. And this has been encouraged by their abuser under the guise of caring to be a stay-at-home parent, and they would be looked after. And as a result, they don't get on with their life and use their qualifications or get any qualifications. And then the discard comes and they haven't been in the workforce for a long time. When that situation arises, I know you mentioned getting, I guess, the equivalent of alimony, where they can get, you can get access resources or put an application in for resources for them, but they want to stay in the home. I guess that's the point I'm trying to get, with the kids, and their abuser won't go. What do they do? Because once the abuser knows, especially that they've got a lawyer, it's even worse. The abuse, it's traumatizing to live separated in the same house. What's your advice? Can you get them out?
I might clarify first. Are we talking about getting them out temporarily, or are we talking about the person retaining the home and the property settlement? Which one?
Well, that would be retaining the house and the property settlement is normally what they want for. Not always. I'm talking more about when it's over and they've got this abuser, they've come to see you. The property settlement is
want them to leave the house.
taking place, and their abuser won't go, even though they know that they've both got lawyers and court proceedings are starting. How do you, or can you, get them out of the house? It's traumatizing for the victim, and more often than not, the abuser is the one with all the money, and they would be able to, I don't know, get a hotel or a rent somewhere else, and they just won't go because they want to make the victim's life hell.
So there's a couple of points. Firstly, I'd reference the fact that spousal maintenance and litigation funding applications would be my first port of call, where there was clearly both income from the husband and assets in the pool available to meet my client's needs. But in terms of physically wanting that person, let's call them the husband in this particular situation, to leave the house, I just posted an article recently about this on my website, actually. So what a person would seek in those particular circumstances, there's two mechanisms to do it. Either you'd go through the magistrate's court and seek a family violence order, so a DVO or protection order. That includes what's called an ouster order. So those kind of applications, I wouldn't say are commonly successful, but they are where there is evidence in the application, and I don't mean evidence of bruises, but I just mean allegations that are made that are quite serious in relation to family violence, such that the court would say that in order to protect my client, it would be best that the other party is ousted from the home. So and that's happening more and more these days.
It is. I was going to ask you about that in light of the coercive control legislation coming into effect. I think it's March in Queensland. Is the family court starting to take notice of the coercive control and recognising it as a form of abuse?
Well, that's a different question from the one you just asked me. So I might finish the question in relation to ousting the other party from the house first. So we were talking about the magistrate's court, but if we're going through family court, which is not as easy to get the order that my client is hoping for, but the article that I've recently published, which explores this issue, talked about a successful application for what's called sole occupancy of the property. And that effectively means that one person has the exclusive right to occupy and the other person has to move out. In the particular case that I explored, the parties had a $200 million pool. The husband and the wife were living in the same house. Husband was away for work, on and off, coming back. They clearly could live separately in the very big house, but it wasn't working because the husband would continue to come in areas that were occupied by the wife, and that was causing her
like the movie War of the Roses, guys. That's what it sounds like.
So it was causing the wife a lot of distress. The evidence was that where the wife was living, which was quite far away from her medical practitioners, was impacting upon her health, and she had some quite serious health diagnoses. So the court in that particular circumstance said that it was best that the wife have the ability to exclusively occupy the property and that the husband move out. But look, it's not an easy application when you're applying for sole occupancy through the family court, and you really have to have you need to have your ducks in a row. When you say prove the abuse, I want to emphasise that it's an interim hearing. The court doesn't make findings of fact. The court looks at the contested allegations and they look at what's agreed between the parties and the independent evidence. And the independent evidence was from both parties that there was a lot of conflict. It was impacting upon the wife. The husband was out of the home more often than she was, and her medical practitioners said her health was compromised by living so far away. So in that particular situation, the court said it was more practical and best to reduce the conflict, that she had the capacity to occupy the property. Now, what was your...
Guys, listen to that. Remember that, because so many of you tell me that you're living in the house with your abuser. If you've got the right lawyer, they'll be able to explore exactly what Courtney has just spoken about in trying to oust your abuser from the house, if possible.
I think you may have been referring to coercive control was the next question. Is that right? And whether
the legislation, I'm just wondering if you're noticing that more lawyers are, I guess, talking about it in terms of what their client has endured, and if so, is there a real understanding? Because obviously it's coming into effect in March next year.
Coercive control hasn't just been a thing that's come up in the last year. It's been an issue that's been quite significant in the family law system for many, many years. I mean, the statistics, I don't have them on top of my head, but more than 80+% of matters that are before the family court have some kind of allegation of family violence. And often that family violence is more insidious, and the coercive control takes the form of the husband requiring receipts to be emailed in relation to everything that the wife spends, or she needs to tell him where she's going, and she has a curfew as to when she needs to be home. It's how often they need to have sex. It's what is she allowed to wear. It's who she's allowed to have over. It's what family members she's allowed to talk to and which ones she needs to cut off.
Being kept on a cash budget, and etc. etc.
So all of that is actually quite common, and the court takes it seriously. Insofar as how it affects the best interest of the children, though, that varies from case to case.
Yeah. Okay. So just quickly, Courtney, in terms of, we were talking about DVOs, and for those of you who aren't in Queensland, that's a domestic violence order. I think it's called an AVO if you're in Melbourne, and probably something different altogether if you're in the States or the UK, etc. But a really common practice that the abuser has to intimidate their victim, I have found, is that puts the victim off from seeking a restraining order to begin with, is to threaten or actually go through with a cross DVO. So, basically they say, you go and get your DVO because I remember when you yelled at me that time, so I'm going to get one too. And it kind of, negates the other one, and it really scares the victim into not seeking one in the first place. What's your advice for a victim when that is ominous or it's happened, the cross DVO, and are the courts looking at that as something that's malicious and vindictive?
What I would say is, number one, it's important that you have a really good lawyer who's very experienced in both applying for and fighting these types of applications, because the difference between having a good lawyer and a not so good lawyer is whether or not you achieve the outcome that you want. The second point I would make is that it's the court's responsibility, the magistrate's court, to determine whether an order is both necessary and or desirable to protect the victim in both applications. And as part and parcel with the Queensland domestic violence legislation, the court needs to assess which person is most in need of protection. Now, that doesn't mean that the court isn't going to make an order, that cross order, ultimately, but it depends on the individual circumstances, and namely, if there has been family violence, whether an order is necessary and or desirable to protect the aggrieved in that particular situation. So it will all come down to evidence at the trial and who the judge believes, and the judge needs to make findings of fact about the evidence on the balance of probabilities, which means that they only need to believe my client 51%, and the other party less, in order for them to make a finding in my client's favour. And the more findings in relation to family violence that there are, particularly the more recent findings, the more likely the court is going to make an order in my client's favour. So I've done a number of articles on boosting your prospects of success in DVO applications. The main piece of advice I would give, if we're talking about how to maximise the prospects of achieving the outcome my client wants, would be to, besides get a good lawyer, be really particular about the allegations and the incidents that have happened. So no general sweeping statements, but talking about the incident from the start to the end, from the time they open the door to the time they rushed out after the incident ended.
Yeah. Yeah, and I always tell my clients to write the application themselves. Not the police don't do an amazing job, but they just don't. They weren't there. They don't feel all the emotion that you had when those incidents were taking place, or write down what happened. Often,
I think that's really important. Yeah, I would say though that the police are getting better and better from the applications I've read at identifying and describing family violence, and a lot of the time victims aren't very good at it. Respectfully, they need support in order to put that to paper, and sometimes police can provide really good support in making it happen. I also think it is very important to identify how it affected the victim, so how it made them feel.
Their emotions, that's what I always say is a big factor, because it's scary, and when the court just hears a series of incidents without the emotion that was there, I couldn't sleep, I was terrified to leave the house, and things like that. That kind of just paints a real picture of what trauma the victim went through. So I know you're busy, Connie, so I think we'll wrap it up with this last question, but and I know there's so many other things that people are going to want to know, but maybe we can do another episode another time. But we're talking about domestic violence orders, okay? So Kat, 2 questions. Can you help the client who is just too intimidated, too scared? Can you support them to get a domestic violence order? And the second thing is, what most victims do, it's typical for a victim to wait till like the 10th, 20th, 50th incident of domestic violence. And but there's just been so much, and they just think, it was like 6 months ago that I had that black eye, and they've been fine for a couple of months. They won't go to seek one because of those factors. And can a restraining order help them? One that's obviously warranted, but can it help them to get their abuser out of their house, to speed up the process with children's custody orders?
I'm trying to understand the question. I think what I've heard is supporting a victim who is scared to get a DVO.
Yes.
I can only support a victim to apply for a DVO if they provide me instructions to do so. So often I have clients who feel quite intimidated and scared of the other party. Ultimately, at the end of the day, they need to be ready to push forward with that process, which can be quite intimidating and scary. So in that regard, ensuring that they have those appropriate support mechanisms in place to help their mental health first, I think is really priority, because that's something that I can't support them with. I can be their legal strong arm, but not their emotional one. And they need to be ready to,
I think
the property settlement or the DVO, to press go.
And I think that's exactly what I meant, in that do you, I guess, encourage them to get protection when they're scared they're going to make their abuser angrier? But if they can get a restraining order, then I would assume, but I'm seeking your clarification around that. I'm assuming that very warranted DVO would help them to get their abuser out of the house, to potentially impact on children's custody arrangements.
Okay, all right. In relation to applying for a DVO, I absolutely advocate for my client to file an application if they're worried for their safety or the safety of their children. I encourage them to do so. If they don't have the funds to engage me directly, we explore the possibility of A, doing their own private application, or B, going to the police and asking them for support. I would say that the police are doing more and more applications on behalf of parties. My understanding, just quietly is that the police these days will file more often than they won't for a party, because if anything were to happen, then they would be blamed for it if they
liable.
took that step. So I think they're doing it much more often than they used to. So I think it's definitely worth approaching the police, especially if there's some evidence, text messages and the like, but you definitely don't need that for the police to file an application on your behalf.
Yeah.
The second question I think you mentioned was referencing whether it would help them in the parenting matter in custody. Is that right?
I know that many of my clients who are successful in getting restraining orders, a lot of the time the children are actually on that order, which, and once again, I'm just a layman. I would assume that would help them to, if there's issues there with them wanting their abuser to leave the home, and also if they're scared of the children, going to with unsupervised contact with their abuser.
So in terms of the other party leaving the house, we explored the ouster order before, which is connected to an application for a DVO. You can ask for a specific condition, which is an ouster order, in order to achieve that outcome, which the court will sometimes order, such that the other party needs to leave the house. In relation to a protection order assisting in a parenting matter, in that it has the children on the order, what I would say, first of all, is that the court will make an order putting the children as aggrieved parties to the order in circumstances where the children have been exposed to the violence or at risk of violence, but usually they've been exposed in some way, directly or indirectly. Now, if the children are placed on the order, that doesn't mean that the other party can't have contact with the kids. So there's a couple of things to bear in mind here. A, the conditions on the order. So if it just says be of good behaviour and not commit family violence and not approach my residence, that doesn't mean that the other party can't have contact. There would need to be a no contact, no communication order, no approach order, that kind of thing. If that was in the order, then that would prevent the children from having contact with the parent. But there is usually, in most circumstances, an exception in the order that specifically identifies except with the written consent of the aggrieved. So usually that's what parties use to be able to communicate and negotiate a parenting arrangement. The other point I would make is that a DVO is a Queensland order, a state order, whereas a family court order is a Commonwealth order. So the family court order, if and when there was one, would override the DVO to the extent it's inconsistent. So an example of that would be if there was a DVO in place for no contact or except with the exceptions, but the parties consented to an order or the court made an order that changeover happened at McDonald's, and then there was some in-person contact between mum and dad for the purpose of exchanging the children pursuant to that order, or there was telephone communication between the child and dad, then that wouldn't be a breach if that was in the family court order. Now that happens all the time because there are so many DVOs, and that doesn't necessarily mean that an order for the children to spend no time with the other parties in their best interests. But what I would also say is that the court needs to specifically identify if there is a crossover in that the family court order does collide with the DVO, how it's inconsistent, and sometimes, or what the family court should do, is send a copy of the family court order to the magistrate's court. Now that's important because you've got a DVO that says one thing and a family court order that says another. So in terms of actioning breaches of that DVO, the police and the court really needs to be aware of what those exceptions
are. Do they communicate? Because that's confusing to me. If because a domestic violence order, the police have the evidence. It's gone to a court, and it's been obviously established that the victim is and perhaps the children are in need of protection, which means they need to be kept safe from that person. So how does a family court who unless they're dealing, directly with the police, how do they override that?
Happens all the time. So I think what maybe I need to explain a bit more is that a DVO 90% of the time is made by consent without admission. So the respondent to the DVO will agree to the order, but not say that they agree to the allegations made. So making the order by consent means that there's no findings that these things are true. Whereas if a matter goes to a hearing and the magistrate makes findings of fact at a hearing, let's say that happens, there's a judgment. That judgment will be available to the family court. That doesn't mean no contact will be made, but it will definitely be relevant to the family court in terms of the orders that are made. But I don't necessarily think just because there's a DVO made that means that no time is in the children's best interests either.
Yeah, maybe not no time, about perhaps no overnight contact or maybe supervised contact. I don't know. I guess it depends on the individual case. But that certainly sounds like one of those loopholes to me for an abuser who wants to weaponize the children, in that they just go, yep, I agree to the DVO, knowing that they're going to get contact through the family court.
I wouldn't call it a loophole at all, actually, because the family court takes that DVO into account regardless of whether there have been findings made at a trial. Ultimately, the court looks at all the evidence, and usually a family report by the time they're looking at making standing orders. So they've got a lot more evidence before them to determine what's in the children's best interest, and often that's a lot more than what was before the magistrate's court when the DVO was made, usually by consent.
So the magistrate's court has got, as you said, the family report, perhaps psychologists,
family court has, yes,
and as well as the information that's on the DVO order and application. Okay, I get it. Look, Courtney, I could sit here. I've got a million more questions, but I know that you've got to go, and I think we'll just make it another episode. And guys, questions. If you've got any questions that you'd like answered, or to do with, family court and what we've spoken about today, just flick me an email, or just send me a message in the private group, and Courtney and I can get together and make those things that you want to talk about a topic for the next podcast. But Courtney, thank you so much, my daughter, for doing this podcast with me. I know so many people will benefit from your expertise. And just quickly, one thing I get asked a lot is, do you just support people in Brisbane? I realise you wouldn't be able to support people overseas, but do you do interstate representation?
All the time. We have clients at the practice that are hours away or interstate. So Family Law Act is a federal act, which means it doesn't matter what state you're in. The only caveat I would give to that is in terms of physically visiting your lawyer to sign documents. If they can't be signed electronically, that might be difficult, but that's something that could be facilitated by them being posted. And secondly, for example, if court is in Victoria and I'm here, there would be more cost associated with me flying to Victoria to attend court. But these days, since COVID, a lot of the appearances are online anyway. So sometimes the interim hearings are in person, but most of the time otherwise it's all online. And even then, if it was in person, we could either apply for leave to appear by Microsoft Teams, or otherwise we can get an agent to attend that court date. In relation to DVO matters, though, I think that's best left with the individual state, because there's different legislation from state to state.
Yeah. Okay. So, I think just to sum up a few main points we spoke about, guys, get a lawyer like yesterday. If you're watching this or listening to this podcast, then you've been abused or you know someone who has, and it's imperative that you get at least legal advice. There are ways, as Courtney said, if you don't, to get access to the resources, so don't let that put you off. But you've got to have a good lawyer, not just any lawyer, because of all of these curveballs that the narcissist is going to throw out there, and they need to have this specific knowledge that Courtney has spoken about.
That's definitely the most important takeaway point, I would say, from today, that there are a lot of family lawyers out there, but choosing the right lawyer who understands what you're up against and how to negotiate with a narcissist is probably the most just important decision you will make post-separation. But I just want to make a final point that this is all general information only. If you want any legal advice about your case, specific to your circumstances, get in contact with us and book an appointment with myself or one of our experienced practitioners at Barton Family Lawyers.
Barton Family Lawyers. So I'll put that in the description for this episode, guys. Barton Family Lawyers in Brisbane, but as Courtney said, they represent people all over Australia. So Courtney, thank you so much for your time today. I will no doubt see you soon, and look forward to working out what we're going to do in the next one.
Nice talking to you, Mum. Bye.
See you. And that brings us to the end of another Fake Love and Flying Monkeys episode. I hope you found that episode insightful, guys. Obviously, there's so many other questions I have for my beautiful daughter, Courtney, who is an expert in her field and very well respected. But I think the main thing to remember is that if you have been discarded and there's property and or children, go and see a lawyer like yesterday. Just think of it as getting legal advice if it just all seems too overwhelming. But on that note, guys, it's bye from me for now. Don't forget to reach out if you'd like to have a one-on-one Zoom counseling session. And of course, don't forget to get your copy of my best-selling book, Fake Love, Understanding and Healing from Narcissistic Abuse. Until the next episode, remember, you are worthy of love, and you are worthy of so much more than a lifetime of fake love and flying monkeys.